Sir, you can take a very clear stand
Yes.
that because of non-compliance in the past,
Yes,
central
Lord.
government has not released funds even for the present. If
Yes.
that is going to be a stand, then we ask the report of the central government as to why you are not releasing funds for the present.
Yes. Well, if your lordships may kindly consider passing an additional direction as to how they have dealt with our repeated letters to withdraw this letter of 9th of March 2022. If that additional direction could be, my lord, considered by your lordship to be passed, my lord, along with, my lord,
My lords,
whatever your, my lords
may kindly
proposes
take the
to
law
pass.
for a moment, my lord.
Pardon?
My lords may kindly take the law for a moment.
Hmm.
Section 3, my lord. It creates a binding obligation on the state government to provide employment.
Sir, no.
Now, my lords, irrespective of whether the paymaster pays or not, it is an obligation on the state government to provide employment, your lordship. It is only, my lords may kindly all see section 3 read with section 7, your lordship.
But along with, my lord, the sections which my learned friend wants your lordships to go through, please take section 22 also.
No, my lord, section 7 once again.
Sorry for interruption.
Yes,
There is a clear demarcation between wage and allowance.
Yes,
Wage,
I quite follow. I quite follow.
That is evident from section 22 as well as section 6 and 7. Section 6 stipulates the wage rate and 7 for payment of unemployment allowance. Unemployment allowance, it's the duty of the state government to do it under the scheme. Whether you get the funds or not, it's not concern of the so far as the act is concerned. And
I'm sorry, Milord. I'm sorry.
But where is the report of the nodal officer?
Please take Milord section.
May I only indicate one
Milord,
thing?
if I may, Milord, make 2 minutes submission, Milord. Kindly, if my learned friend can allow me 2 minutes time, Milord.
Yes,
Milord,
yes.
Please take, Milord, section 7 on the unemployment allowance aspect.
Yes.
Where it says if an applicant for employment under this scheme is not provided such employment within 15 days of receipt of this application seeking employment or from the date on which the employment has been sought in the case of an advance application, which is later, he shall be entitled to a daily unemployment allowance in accordance with this section. Therefore, Milord, unless the scheme is in operation, the persons cannot apply. And if they cannot apply, Milord, then the question of, Milord, providing jobs or failing to provide jobs, Milord, in my very humble submission, cannot apply.
No, therefore, no, sir, the scheme has not been suspended. The
Milord,
payment of grant given by the central government towards wages has been put on hold.
Yes.
So therefore, the plain simple reading of the statute will show that if you are unable to provide employment for any reason, the reason here is because central government has not sanctioned the fund, it has stopped the funds, the inquiry is going on. Then it goes without saying that these people are unemployed. The unemployment allowance has to be disbursed in terms of section 7, read with subsection 2 of section 22 by the state government.
Milord, if I may, Milord, once again, Milord, trouble your lordship, Milord, with the 9th March letter.
9th March, what happened is after 9th March, the AG says that some 24 compliance reports have been submitted. You are sitting tight on that.
So far as 9th March order is concerned.
After 9th March.
After 9th March, so many things has happened.
No, so many things have happened here.
Yes, yes.
But what the learned advocate general says is they have given you compliance report. Either you decide or not decide. You come to subsection 2 of section 27. The last 3 sentences. Yes. But if necessary, order the stoppage of release of funds to the scheme and institute appropriate remedial measures for its proper implementation within a reasonable period of time.
Yes.
So you can't be sitting tight on that. Either you say that the compliance report is no compliance or partial compliance or for XY reasons I can't accept. You pass an order.
Yes, we'll do that. So far as that part is concerned, Milord, your lordship will kindly consider. Milord, inquiry is being conducted. Milord, your lordship has set up an inquiry committee also.
That inquiry committee is supposed to give a report to its nodal officer. That report is not there.
Not coming. And not only that, my lord, if your lordship will not kindly see me on the last occasion, it was
And
submitted.
who's the nodal officer, AG?
Your lordship, Your lordship, it's the additional chief secretary, finance department, your lordship.
Yes.
He could have made a one-page report at least.
Yeah.
This all happened. The committee met on these days. This is how we have proceeded. That is why this matter we listed it today on the eve of the vacation. Why?
My lords, may I only indicate one thing, your lordship?
What do you want?
My lords, may kindly take the order dated 9th March once for a
9th March is.
Please, once for a moment, your lordship.
Yes,
just for my satisfaction.
Read.
Now, 10.2, my lords, reads, further, the fund transfer orders for wage payment generated from the date of this order will be paid by the state government from its own resources, and it will be continued till necessary compliance with reference to point. Therefore, my lord, it's essentially...
That they are challenging. See, the state is challenging that. You remember, not the present learned advocate general, his predecessor in office, said that that portion of the order we are challenging. Whether they can pass such an order is an issue. But by then what happened? Crores and crores of money went elsewhere. Whole thing got derailed. Several directions issued from time to time.
My lords, my
All right,
limited
please,
cases,
please.
your lordship.
Wait.
My limited cases, your lordship. I have right to... I have,
Sir, nothing
my lords, may kindly allow me to make my submission for a moment, your lordship.
Yes.
My limited submission is, your lordship, I have statutory right to walk. This is protected under section 3, read with section 7. My lords, I cannot be deprived of my right to work because of the differences between central government and state government. This must go on. Work must go on under Manrega. Whether the central government pays them or not, that's not my concern, your lordship.
No, in terms of wages, central government has to release. In terms of unemployment allowance, we put it to the AG. Let the AG make a submissions on that. Why we can't issue a direction?
My lords, pending decision on this particular issue, whether central government has competence to issue this direction on section 27 or not, shifting burden from the central government to the state government, let the walk start, your lordship.
Right.
May I submit one thing? Paragraph 5 of your lordship's order, it was submitted on the last occasion. It is submitted that for the nearly 2 years, no job have been allotted, as a result of which people are suffering. So, for the last 2 years, state government is...
You are also sitting tight on their compliance report. You have not passed orders. You tell them that this is no compliance at all. We are not accepting your compliance report. You pass an order. Reference may be made to the order dated 26/9/2024. In paragraph 1 and 2 of the said order, there is a specific direction to the nodal officer who was nominated by the state government, nodal officer of the committee which was constituted, to submit a report. However, submit a report after taking appropriate instructions from the committee so constituted. However, no report has been submitted today. The learned advocate for the writ petitioner would contend that in terms of the scheme of the Act, regardless of the fact that the central government have not released funds under the scheme, it is the obligation of the state government to provide employment and also pay wages. This issue needs to be adjudicated. Prima facie, on going through the relevant provisions of the Act, more particularly Section 3, Section 6, Section 7, Section 22, and Section 27, read with Schedule 2, there are two distinct aspects which is provided under the scheme. One is for providing employment for which wages have to be disbursed in terms of the wage rates stipulated in Section 6 of the Act. The other is payment of unemployment allowance in terms of Section 7. It is not in dispute that the central government has exercised its powers under Section 27 of the Act and has passed an order on 9/3/2022 stopping release of the funds under the scheme to the state government. Until the state government ensures compliance of the directives of the central government with respect to the inquiry reports of the central team led by the joint secretary within bracket RE and director RE within bracket RE. Further, there is a direction that the fund transfer order for wage payment generated from the date of the said order, namely 9/3/2022, will be paid by the state government from its own resources, and it will be continued till the necessary compliance with reference to the above condition. Full stop. The other direction is the pending wage payment and material payment, if any, prior to the date of the order, dated 9/3/2022, will be released by the central government. The learned Advocate General appearing for the state submitted that more than 20 compliance reports have been submitted to the central appropriate authority of the central government pursuant to the orders dated 9/3/2022, and the state government has also contested the direction issued in paragraph 10 within bracket 2i's of the order dated 9/3/2022. The learned advocate appearing for the central government is directed to get specific written instructions as to what orders have been passed pursuant to the reports submitted by the state government, which according to them are compliance report pursuant to various directives issued by the investigating team. This report should be positively filed by the concerned officer on the next hearing date. The next aspect is, please take that out. As pointed out earlier, in our prima facie view, there are two aspects under the scheme. One is payment of wages and another is payment of unemployment allowance. It is the submission of the learned Advocate General that unless and until the funds are sanctioned by the central government, the question of payment of unemployment allowance by the state would not arise. In our privacy view, we are unable to persuade ourselves to accept the said submission, since the Act makes a clear distinction between payment of wages for the work allotted and payment of unemployment allowance. So as on date, the employment has not been provided by the state, citing the reason that the central government has stopped releasing funds. If that be the case, it goes without saying that the people are unemployed. If people are unemployed, in terms of Section 7, they are entitled for unemployment allowance. And subsection 3 of Section 7 states that the liability of the state government, subsection 3 of the Section 7 fixes the liability for payment of unemployment allowance on the state government. This being a prima facie view, we direct the state government to answer as to why a direction should not be issued to the state government for payment of unemployment allowance, since admittedly employment has not been provided to the unemployed for the past 2 years. Thus, the following directions are thus: in terms of the order dated 26/9/2024, the nodal officer of the committee has to file a report. Full stop. The appropriate authority of the central government has to file a report with regard to the stand taken by the state government that they have submitted more than 20 compliance reports pursuant to the order passed by the central government on 9/3/2022. And thirdly, the state government shall answer as to why a direction should not be given to the state government for payment of unemployment allowance. List the matter on so and so date.
Let me kindly record my submission. Let me kindly record my submission.
Yes, I have recorded. No?
Regarding resumption of the scheme, I submitted specifically that because of the departmental differences between central and state government, Manrega Act cannot, implementation of the Act cannot be withheld.
The learned advocate for the writ petitioner would contend that though there may be differences between the central government and the state government, the operation of the scheme under Act 42 of 2005 cannot be put on hold. This aspect will also be considered on the next hearing.